All rise. We will lever. Please be seated. We use the swap.
Thank you very much. We'll resume hearing with the observations from Amici Courier. Mr. First, Mr. Paweł Wieliński. Sir, you have 10 minutes. It starts now.
Thank you, Mr. President, Your Honors. I'm very honored to be here, not representing victims or any party of the proceeding, but being here as amicus curiae. I just want to say at the very beginning that professors from my faculty were members of Polish delegation to the Nuremberg trial. They were presenting victims' testimonies of grievous atrocities. And that time, victims had very limited rights and being mostly source of information for the trial. Many have changed from that time. We made tremendous steps forward. But today, we are here again, and I believe we are here to answer how important victims are. And that's the reason that I requested for standing here as amicus curiae. This is in fact the essence of today's hearing, as I see it, and reason of my presence. Why victims stand for right to appeal in this case? One can say that as far as prosecutor already launched an appeal and it was granted, there is no need for that. And why tomorrow's allies, I mean Thursday and Friday, on the merits of appeal, this is prosecution and victims, argue against each other today? Why victims want to stand for the right to appeal? I understand that it is because victims standing, if will be denied next time or any other time, if prosecution will not find an interest or will find no reason to appeal against such decision of non-authorization of investigation, there will be no one to appeal. There will be no appeal. And the victim's path to bring justice and compensation to victims will be closed. It is therefore, from my point of view, not true that victims have no interest here. This is probably also the reason why it would be most desirable to have this clearance about victims' positions before Thursday and Friday hearing, if they will represent their interest as parties to the proceeding or not. So, what victims, as I believe, have to prove here and today? I believe, and having a restrictive time, that they have to prove two things. First, that decision of non-authorization of investigation influences their interest, and I call this like proof of the merits in this case. And the second, that the statute gives them the floor for an appeal, and that's the proof of procedure. Before I will refer to both, one comment. I want to bring your attention to the stage of proceedings that we are, because it matters. The subject of the hearing in this case is the situation in Afghanistan. It is the preliminary procedure. Only if there will be an investigation and then successful confirmation of charges there will be a case or many cases. We will have parties with their rights to fair trial, with right to compensation for victims. But now we are at this stage of situation in Afghanistan. Will they have this right if the investigation will not be open? Will they have this right for compensation? Probably not. We have to understand and we have to remember that victims are actors of the situation and they are parties of the conflict arising from the crime. Therefore, they have good standing to represent their interests already at this stage, as the decision is likely to determine further existence of proceeding itself. Persons become a victim long before the criminal investigation is initiated. It is very important to understand that. For this reason, it is not consistent with the common sense of justice, depriving him or her of the possibility to participate to procedure of controlling the decision not to initiate proceeding, if such procedure exists. So, victims have more than any other actor interest to question denial of investigation, not as an element of fair trial, but as right to effective legal remedy, or we can name this any other way, against decision that deprives victims' right to justice and compensation. For these reasons, I believe that proof of merits is, therefore, in this case, met. What about the proof of procedure? It is not a surprise that the statute and rules of procedure and evidence give not a detailed description answering all procedural questions and situations, but gives us rules, as its name gives us rules that we have to follow, that we have to interpret in the interest of justice, to bring justice at international level. We can read about these even in the preamble to the statute. And that is the essence of the court existence, in my understanding. Misunderstanding of interest of justice based on arguments used by pretrial chamber gives floor to follow wide understanding of Article 82(1)(a), or maybe also D, on admissibility and jurisprudence. What victims have to prove here and today? The essence of court's decision based on revision of the appeal will focus on that if the court will execute its jurisdiction or not. If will execute its jurisdiction in Afghanistan or not. It is then a question of jurisdiction and can be understood and read in this way. And I believe that for that reason the proof of procedure is therefore in this case met. When we take all arguments and reduce all raised today arguments and issues to its essence.
Excuse me, you have 2 minutes left.
Then we have just one question. How important victims are? I believe they are. Thank you, Your Honors.
Thank you very much, Mr. Wilinski. And now the Jerusalem Institute of Justice, the International Legal Forum, My Truth, the Simon Wiesenthal Center, the Lawfare Project, and UK Lawyers for Islam. You have 10 minutes. It starts now. Please proceed.
Good afternoon, Mr. President, Your Honors. The organizations we represent today, Stephen K., Joshua Kern, and myself, which you have just mentioned, are aware as human rights organizations supporting affected communities' rights in Israel and Jewish communities in the diaspora, of the importance for the ICC to hear the concerns and views of victims and affected communities. Concerning issue A, if the court were to consider interpreting the notion of parties in Article 82.1 broadly, we would suggest adopting a purposive concept of interests affected by the decision, which would in turn justify considering taking as a starting point affected communities rather than simply victims. In that sense, we note that the submissions made by the representative of victims this morning all support our position, and particularly the conditions put forward by the representative of LRV1 also apply to affected communities. We also note that the concept of affected communities is a regular feature of the ICC's work. For example, in the context of the mandate of the Trust Fund and outreach activities, appears both in ASP documents, judicial decisions. It appears 6 times in the OTP strategic plan for 2019-2021, and also in the regulations of the registry. Using the concept of affected communities on whose interests a decision impacts in order to recognize certain procedural rights, including, in some instances, rights of appeal, will support the capacity of the judges to take into account at all stages of the proceedings, including Article 15 proceedings, all the elements required to reach an informed decision. In relation to Group B issues, the central question is how narrowly or broadly one understands the notion of jurisdiction under the Rome Statute. If one looks at the language of the statute, the only provisions relating to jurisdiction in a strict sense are Article 5 on material jurisdiction, Article 11 on temporal jurisdiction, Article 25.1 on natural persons, and Article 26 on the age of the defendants. Indeed, Article 13 concerns, as has been mentioned, the exercise of jurisdiction, while Article 12 relates to the preconditions to the exercise of jurisdiction, so can be considered as not strictly speaking a jurisdiction provision in this sense. Under this strict view, only issues pertaining to Articles 5, 11, 25.1 and 26 would fall under jurisdiction as per Article 82.1a. Should the appeals chamber decide to adopt a broader understanding, it remains to be determined what it would cover, particularly when it comes to Articles 12, 13, and interests of justice under Article 53. Regarding Article 12, understanding how it should be applied from a jurisdictional perspective requires distinguishing between at least 2 levels of relationship. The first level is a relationship between the court and state parties. This perhaps is the easiest one to deal with, as that relationship can be conceptually understood as being based on consented delegated authority from state parties to the court to exercise jurisdiction in a certain situation. The second relationship is maybe more complex, that is between the court and non-state parties, which by definition have not given their general consent to the court exercising jurisdiction, for example, over their nationals. It is argued by some that such a situation is not problematic, because if individual states are able to exercise jurisdiction in their domestic courts over nationals of other states, why could they not delegate such jurisdiction to the ICC? These matters should, in our view, be dealt with in a more nuanced fashion. Indeed, the rule of general international law that allows states to exercise territorial jurisdiction over nationals of other states did not come about ex nihilo. It is a permissive rule of international law that has developed over time as an accepted principle in the particular context of interstate relations, as crystallized in the Lotus case at the PCIJ. It cannot be assumed that such a rule can be automatically transposed to the relationship between the ICC and non-state parties, which requires identification of specific rules of customary law that apply to such circumstances. In relation to this, we note that this reasoning follows naturally from the case law of the court itself. The Appeals Chamber, in its 6th of May 2019 judgment relating to head of state immunities, found that an international court, and therefore the ICC, had, and I quote, paragraph 116, a fundamentally different nature than a domestic court. What is interesting here is the consequence that the Appeals Chamber drew at the time. That the ICC was not bound by interstate rules of immunity, and that a specific and distinct rule of immunity had to be identified in the context of the relationship between the ICC as an international court and third states. If we apply this logic here, this means that the ICC is not permitted to exercise jurisdiction over the nationals of non-consenting third states without identifying a permissive rule of international law allowing such exercise of jurisdiction. Yet, there is currently little evidence that such a rule exists, absent a blessing from the Security Council acting under Chapter 7. Moving on to Article 13, a question that arises is whether the opening of an investigation should be considered as an exercise of jurisdiction by the court. In that respect, a plain reading of Article 13c actually suggests that the exercise of jurisdiction would only take place after the prosecutor has initiated an investigation under Article 15. And that therefore, technically, the opening of an investigation would not be an exercise of jurisdiction within the meaning of Article 13, even if each and every act that follows is, such as cooperation requests or arrest warrants. However, a broader approach is possible, to consider that any issue which ultimately is material to the capacity of the court to exercise jurisdiction should be considered jurisdictional in nature. And we've heard examples of this today. There is logic to this argument, and it would mean, in the present situation, that a decision authorizing the opening of an investigation could...
You have 2 minutes left.
Thank you. In a broad sense, fall under Article 82(1)(a). Yet as a consequence, a great number of ICC decisions would have to be considered jurisdictional in nature, because they might have an impact on the court's capacity to exercise jurisdiction. To give but a few examples, a decision on state cooperation, a decision on the confirmation of charges, or a decision to issue an arrest warrant. If the Appeals Chamber follows this logic, it must therefore be ready to extend Article 82(1)(a) to all matters which have some material impact on the court's exercise of jurisdiction. Finally, there is a question of whether a decision on the interest of justice is jurisdictional in nature. In that respect, one could argue that because Article 53 of the statute explicitly distinguishes 3 criteria, jurisdiction, admissibility, and interest of justice, and that Article 82(1)(a) only mentions 2 of those, jurisdiction, admissibility, there is not much room to read interest of justice into Article 82(1)(a). The only way around that is again to adopt a broad interpretation of the interest of justice, of the jurisdiction and the exercise of jurisdiction. This needs to be addressed specifically because even if other aspects of the decision are deemed to be jurisdictional, it has to be proven that interest of justice is jurisdictional for an appeal to be possible on that specific point. We stand ready to develop any of these points further, orally or in writing, at the request of the Appeals Chamber. Thank you.
Thank you very much. The European Center for Law and Justice. You have 10 minutes, Please proceed.
Thank you, Mr. President, Your Honors, and may it please the Chamber. I'm here today on behalf of the European Center for Law and Justice. The ECLJ has been participating in making submissions to this court and to the Office of the Prosecutor for a decade. As I said earlier, my name is Jay Seculo. I have the privilege of appearing before you today, but also the privilege of serving as the ECLJ's Chief Counsel during this time of cooperation with this court and with the Office of the Prosecutor. The first question before this chamber is whether the pretrial chamber's assessments under Article 53(1)(c) are jurisdictional for the purpose of Article 82(1)(a). The answer to that question is yes, for several reasons. First, when the prosecutor submits a request for authorization to investigate, she triggers a jurisdictional analysis because the pretrial chamber is required to engage in the same reasonable basis analysis under Article 15(4) as the prosecutor does under Article 15(3). Thus, pursuant to Article 53(1)(a), that reasonable basis analysis includes addressing any questions concerning jurisdiction. Second, it is jurisdictional precisely because a decision with respect to jurisdiction and admissibility must include when and how the court may exercise jurisdiction. A decision with respect to jurisdiction includes one preventing the exercise of jurisdiction. Third, while determining the existence of a reasonable basis to proceed, the pretrial chamber reviewed the various requirements for jurisdiction and admissibility. In Section 5 of the opinion, it looked at the questions of subject matter and territorial jurisdiction. In Section 6, it looked at whether the case was admissible under the complementarity threshold and the gravity threshold. And in Section 7, it looked at the decision whether the decision to investigate would serve the interest of justice. All of these are important determinations with respect to jurisdiction and admissibility. And for the pretrial chamber's filtering role to be effective, it must review all of them. As described in paragraphs 44 and 94 of its decision, the pretrial chamber's rationale to not exercise jurisdiction is largely founded on the expectation that an investigation will encounter at best non-cooperation and at worst active resistance from non-party states. That is why, as indicated in our request for leave to appear before this chamber, we advocate a cautionary approach with respect to adopting an expansive view of the court's jurisdiction. The pretrial chamber's acknowledgement of this resistance is not only about efficiency, it also recognizes that such resistance is foreseeable and not a matter of speculation. This is especially true given the widely held legal positions disputing the court's jurisdiction based on well-established principles of customary international law. Indeed, the very existence of cogent legal arguments disputing jurisdiction is itself a substantial reason to believe that an investigation would not serve the interest of justice. Among the broader considerations that we urge this chamber to review while addressing the question before us is the necessity of allowing proper consideration of jurisdictional issues in a timely manner. Article 15(4) provides that the pretrial chamber's decision does not prejudice future findings on jurisdiction or admissibility. However, in accordance with the spirit and purpose of Article 19, questions relating to jurisdiction should be raised at the earliest opportunity. This would obviate unnecessary proceedings which are a severe infringement of an accused person's rights. It would also be a massive drain on the court's resources. As the trial chamber noted in paragraph 40 of its decision on the motion for a declaration on unlawful detention and stay of proceedings in the situation in the Democratic Republic of Congo, and I quote, "It is in the interests of all, and primarily of the suspects who have been deprived of their liberty, that the issue of possible unlawfulness of their detention be raised and addressed as early as possible during the pretrial phase. Such a requirement is justified by the need to settle at the start of the proceedings any issues that could delay or obstruct the fair conduct thereof." The availability of a separate appeal procedure on preliminary issues, such as jurisdiction and admissibility, as distinct from appeals on convictions or acquittals, is, in our view, crucial to the efficient functioning of this court, as well as the interest of justice, as highlighted in this very case. The prosecutor here was attempting to press ahead against nationals of a non-cooperative, non-state party ex parte, without any opportunity for that state's legitimate objections to jurisdiction to be considered. And the pretrial chamber reached the impugned decision on relevant matters under Article 15, including the interest of justice, without fully considering the critical information about jurisdiction and admissibility. In the case of the United States, for example, these threshold objections would include, first, the principle of customary international law, whereby a treaty does not create either obligations or rights for a third state without its consent. Second, the existence of specific treaties between the United States and the Islamic Republic of Afghanistan, giving the United States exclusive jurisdiction over its personnel. And finally, the principle of complementarity, because the United States is demonstrably both willing and able to investigate and prosecute its own cases. As noted in paragraphs 17 and 18 of the pretrial chamber's Kenya's Article 15 decision, when the Rome Statute was being debated, there was a deep fear that, and I quote from the opinion, that providing the prosecutor with such excessive powers to trigger the jurisdiction of the court might result in abuse. The drafters sought to answer these concerns, and again quoting from the opinion, through the current text of Article 15 of the statute, which subjects the prosecutor's conclusion that a reasonable basis to proceed proprio motu with an investigation exists to review of the pretrial chamber at a very early stage of the proceedings, namely before the prosecutor may start an investigation into a situation. That is why the pretrial chamber is statutorily required, in our view, to consider these issues as part of its reasonable basis analysis. And that is why these issues should be subject to appeal under Article 82(1)(a). If it please the court, thank you.
Thank you very much, Mr. Sekulow. The global rights compliance, your 10 minutes begins now. Please proceed.
Thank you, Your Honours. As indicated in paragraphs 8 to 11 of our request for leave to submit observations, we submit the victims have standing to initiate an appeal. Our arguments are in the alternative. First, we argue that victims have standing as a party to initiate an appeal pursuant to 82(1) in the context of these proceedings, that they qualify as parties in circumstances such as these, where their legal interests are so affected and where the outcome of these proceedings define whether victims have access to justice at all, and we adopt the victims' submissions on these issues. In case the appeals chamber doesn't find these arguments persuasive, we argue in the alternative that victims have standing pursuant to Article 68(3). In sum, that where victims' interests are affected, Article 683 provides victims with the right to express their views and concerns at any stage of the proceedings determined appropriate. Moreover, it obliges the court to determine the precise manner in which this shall occur, constrained only by the requirement that any modality must not be prejudicial or inconsistent with the rights of the accused and a fair and impartial trial. As recognized by Judge Mindua in his partially dissenting decision, dated the 17th of September 2019, at paragraph 27, it is through Article 683 that the judges must determine the participatory rights of victims. We submit that that determination must involve designing appropriate modalities to ensure the full expression of those views and concerns, and in a manner that gives full effect to the relevant provisions and the purpose
of the victim-centered statute. In the silence or ambiguity of the Rome Statute, the manner in which views and concerns are presented and considered must be interpreted to ensure meaningful victims' participation. Meaningful, effective, and independent. It follows, we submit, that the more compelling the interest, the more those modalities must empower. In the prevailing circumstances, Article 683 in our submission dictates that victims express or be allowed to express their views and concerns by way of initiating an appeal. We submit that Judge Mindoa's approach to Article 683 is correct and is also supported by the ICC's jurisprudential history. The ICC has recognized that designing specific modalities may, according to the circumstances, be essential to ensure effective participation. As Ms. Hurst touched upon this morning, this has already effectively occurred. Even in circumstances where the text of the Rome Statute or the rules appear on their face to limit participation to only the prosecution and defense, both ICC trial and appeals chambers have shown a willingness pursuant to Article 683 to design modalities that allow victims to express their views and concerns in a manner that provides them with competencies that appear to be reserved for parties. Specifically, this can be most clearly seen in relation to the submission of evidence, the challenging of the admissibility of evidence, and the inspection of evidence. In relation to the submission of evidence, Article 648b and Article 693 state that only parties have that right. In relation to challenging the admissibility or relevance of evidence, Article 649 provides that this right only vests in a party. Finally, in relation to the inspection of evidence, Rule 77, 78, 81, and 82 expressly provides rights to only the prosecutor and the defense. However, in each instance, and in opposition to the prosecutor's arguments and floodgate fears, both trial and appeals chambers have concluded that Article 683 empowers them to decide on modalities that provides rights reflective of those apparently vested in only the parties. Hence the decision on victims' participation rendered in the Lubanga case on 18th of January 2008, victims, along with the parties, were permitted to submit, challenge, and inspect evidence. In each instance, the Chamber considered that the victim's interest was sufficiently affected, Article 683 was engaged. In light of those interests, the victims ought to be able to express their views and concerns in the same way as the parties. Of course, in each instance, the Chamber was concerned to ensure that modalities were consistent with the object and purpose of the statutory framework. In relation to submitting evidence, the trial chamber concluded that this modality was congruent with the trial chamber's authority to request the submission of all evidence that it required for the determination of truth under Article 693 of the statute. In relation to challenging evidence, a right, as I say, reserved apparently for parties, the Chamber decided that victims could express their concerns through challenging the evidence on a case-by-case basis in circumstances which were, as the Chamber found, commensurate with the fair trial rights that were engaged in Article 694. Similarly, in relation to inspecting evidence, the trial chamber in Lubanga found it consistent with the overall thrust of the procedural framework. Numerous trial chambers have adopted this approach in relation to inspection. The appeals chamber in the Lubanga case also endorsed such an approach. The appeals chamber examined Article 683 and the relevant statutory and regulatory framework and concluded that victims could indeed exercise the modalities of submitting and challenging evidence. Indeed, they were necessary in the circumstances to ensure effective and meaningful participation. The approach we urge as an alternative corresponds, it seems, with the prosecutor's position in the current proceedings. At paragraph 34 of the consolidated response to the victims, they appear to accept, at least in the case of states, that the critical question concerning who might be considered a party for the purposes of initiating appeals rests upon two threshold questions. One, whether the actor in question has sufficient interest in the specific proceedings.
You have 2 minutes left.
Thank you. And two, whether the modality envisaged is consistent with the broader procedural scheme of the statute. As for question one, it is difficult to envisage a situation where the victim's interests are more compelling. We adopt the victim's submissions on these issues. As regards question two, we submit that the broader procedural scheme of the statute designed to provide proactive victims' rights, as contained in Articles 15.3, 53.1c, 19.3, 21.3, and Rules 50, 59, and 93, is wholly consistent with recognising victims' rights to be able to express their concerns and interests by initiating an appeal. In our submission, the combination of these aspects of the procedural scheme tend inexorably towards the right to initiate an appeal. First, victims have a specific and independent right to participate in the Article 15 proceedings. Second, Article 53.1c obligates the prosecutor to consider the interests of victims in deciding whether to initiate an investigation into a given situation. Third, as we've heard from the victims, and we adopt those submissions, victims have specific rights in proceedings relating to jurisdiction and admissibility. Fourth, Rule 93 allows the chambers of the court to seek the views of victims on any issue. Fifth, the right of victims to initiate proceedings, for instance, by filing applications and requests through 68.3 has already been recognised in the court's jurisprudence. Sixth, and finally, Article 21.3 requires the court to interpret its provisions in line with international human rights law. At a minimum, this requires acknowledgement that a victim's right to remedy is fundamental and requires corresponding protection. In our submission, there can be no question of any floodgate fears. The victims would need to demonstrate on a case-by-case basis. Whilst in the present circumstances, such an application would be difficult to resist, if not impossible to resist, it would nevertheless ensure even greater control by the court.
Excuse me, Counsel, the time is over.
Those are our submissions. Thank you. Thank you, Your Honour.
Thank you. Thank you very much, Counsel. The Afghanistan Human Rights Organization is the last of Amici Curia that asked for making submissions related to the preliminary questions considered today. You have 10 minutes now, please. Proceed.
Good afternoon, Your Honours. Good afternoon, Mr. President. It is my honor and privilege to appear before you today on behalf of 17 human rights organizations based in Afghanistan. These are organizations that have spent the last 2 decades enduring conflict and violence to service war victims and human rights victims in Afghanistan. These are organizations that are truly on the front lines, having helped thousands of Afghans over the past years, and in the past 3 months alone, have surveyed and interviewed hundreds of Afghans so that you can benefit from direct voices on the ground in Afghanistan. Based on our observations and our communications with victims, fundamentally what victims want is to be taken seriously, to have their voices heard, to be genuinely understood, and to know that their opinions and hopes will not be sacrificed, marginalized, or abused for political purposes. Your Honors, it is our contention that the pretrial chamber failed in all of these respects And we believe that the outcry that you hear today, including questions concerning this court's legitimacy, is a result of those failures. Our submissions today and on Friday are intended to aid you in remedying those mistakes. Your Honors, in relation to your Group A questions, we agree with our colleagues that victims have standing to enforce their rights during the pre-investigative stage. But where we differ from our colleagues is the scope of that standing. We submit that the standing victims enjoy is coextensive or coterminous with the rights or obligations victims enjoy under the statute or the court's legal text, which under Article 15.3 is to make representations before any Article 53 decision. Here, our submission is that right was denied, and that it is essential for this chamber to address that denial, regardless, but particularly, if this chamber chooses to deny victims a right to appeal decisions made under Article 53. Absent appellant guidance on Article 15.3, which is currently lacking, Your Honors, future chambers of this court risk alienating victims the same way pretrial chamber 2 did in this situation. Your Honors, as you well know, the statute guarantees victims the right to make representations under Article 15.3. Those representations are also necessary for any Article 53.1c inquiry, which explicitly requires an assessment as to the victim's interests. And there is simply no substitute for that assessment than the opinion of the victims themselves. The right to make representations, however, has to be effectively enabled. This means that victims must be notified and have sufficient information concerning their rights and be given a reasonable opportunity to make representations considering their specific circumstances. Because without these requirements, the process of soliciting the opinion of victims would be reduced to a formalistic exercise that gives the appearance, but not the reality, of meaningful victim input. It is, Your Honors, reasonable, timely, and accurate notice in particular that allows victims to assert their rights and facilitates their participation. It is the door through which all other rights for victims are afforded. The fact that representations must be effectively enabled is supported by statements by the Assembly of State Parties, international human rights instruments, and national laws concerning victim participation, the authorities of which, Your Honors, I point to in pages 3 to 9 of our table of authorities, which you can find in tab 1 of the binder that we have provided you. In this case, however, pretrial chamber 2 failed to effectively enable victim representations, especially by Afghan women and Afghan children. And the evidence for that is summarized on pages 14 to 16 of our table of authorities, which reference sworn declarations by leaders of civil society organizations who worked with the registry in the victim outreach process and who are eyewitnesses to the victim representation process. As those victims detail, the outreach process in this case was flawed to such an extent as to bring into question the sincerity of the pretrial chamber's invitation to victims. For example, victim input was solicited via an online intake process, even though only 15% of Afghans have internet access and only approximately 30% are literate. The representation period was only open in the months of December and January, even though those are the coldest and least traversable months in Afghanistan. The registry had no presence in Afghanistan and had no outreach or public information activities in the country to try to reach victims directly. The pretrial chamber failed to order a mass media campaign using Pashto or Dari-speaking radio or television, the primary means through which Afghans obtain information. And the pretrial chamber failed to provide victims sufficient time. It provided victims 2 months, a period wholly insufficient for a country where information about the ICC was scarce, where the court lacks a physical presence, where ongoing conflict hampers access to many of the areas, where many people are illiterate and do not have internet access or stable electricity, and where, Your Honors, for very good reason, the population has learned to be careful about sharing information that may subject them to harm. These errors had a clear and discernible impact on the ability of Afghan victims to make representations. In a country of over 35 million people suffering 4 decades of war, where 69% of the population are believed to be victims of war-related violence, only 699 victim representations were received by the registry, only 165 from individuals. And for that, Your Honors, I refer you to paragraph 23 of the registry's report, annexed to filing 29. But equally grave is the fact that the pretrial chamber took no measure to enable representations by women or children who are victims of crimes, as required under international human rights law, the authorities of which you can find on pages 10 to 14 of our table of authorities. For example, with regards to child victims, of which there are hundreds of thousands in Afghanistan, the pretrial chamber and the registry failed to provide child-sensitive materials and information services. Further, no efforts were made by the pretrial chamber or the registry to target or accommodate Afghan women and girls who are faced with systematic violence and human rights violations, including sexual violence, abuse, and trauma. As Your Honors are aware, many Afghan women, female victims, feel an acute sense of stigma and shame in sharing their stories. They often also face the additional hurdle of having to seek permission to leave home or needing to be accompanied by a male relative. Yet nothing was done.
You have 2 minutes left.
Thank you very much. Yet nothing was done to ensure that these women were properly informed of proceedings and how they could participate. And instead, all efforts and all appeals by leading women's rights groups in Afghanistan for more time to ensure that women were properly represented were ignored. And Your Honors, in support of this, I draw your attention to tab 7 of the binder, of your binders, which contains a declaration by one of Afghanistan's leading women's rights figures, as well as copies of her communications with the registry on precisely this issue. Your Honors, this deliberate disregard for the situation of women and children had a considerable impact. Only 10 representations were made on or behalf of women, and only 9 representations were made on or behalf of children. And I refer you to pages 10 to 12 of the registry's report, annexed to filing 29. And when the pretrial chamber was informed of these massive deficiencies, no corrective action was taken in the over 420 days between the end of the representation period and the chamber's Article 53 decision. Your Honors, in his separate opinion, Judge Mendua claimed the ICC to be a victim-centered court. In our opinion, however, the errors that we have just described, especially when you consider them collectively, demonstrate that the pretrial chamber did not sincerely or genuinely solicit the opinion of Afghan victims. And the victims now turn to you to right that course. Thank you for your time.
Thank you very much, Counsel. Office of the Prosecutor, you may briefly respond, if you wish, to the observation of the amici curiae you have. I would like to ask you to keep the 5-minute time limits.
And I certainly intend to do so, Your Honors. I will first make clear that I will only be responding to the issues that squarely fall within the parameters of this appeal, and accordingly I will not be touching on the issue of whether this court can exercise jurisdiction over nationals of non-state parties, which is not an issue before you. Your Honors, this has been a very important hearing. I think we will all agree on that, and we have heard some powerful stories that remind us of the wisdom behind the decision of making victim participation a central feature of the Rome Statute. But, Your Honors, there was no need for standing for this. All the submissions that you heard today, all the stories that victims presented to you today were stories and submissions that could have been made, and probably may have been made even, in the context of the ordinary participatory rights afforded by the statute. So in this sense, for us, this is proof that the Rome Statute system works. There is no need for you to create an extra statutory remedy to provide victims for their independent voice to be heard. They have that right already, and they have exercised that right today. In this sense, Your Honors, we agree with OPCV that the Appeals Chamber is in a position to decide on all the issues, all the critical issues, regardless of whether you decide to go via the Article 82.1a route or the Article 82.1d route. And it was in this sense that we referred to the issues of standing and jurisdiction as technical issues, not in the sense of diminishing somehow their importance. In general, I will rely primarily on our written submissions in response, but perhaps a couple of points to be made. First one is there may be some degree of confusion as to what decision under Article 15.4 denying commencement of an investigation under the interest of justice limb actually means. There is no estoppel or obstacle preventing the prosecutor from renewing an application, even on the same subject matter, on the basis of new facts and new evidence. So the possibility of returning to the pretrial chamber and starting again the process, so to speak, always exists. And actually, it may be that in certain circumstances, the prosecutor concludes that it is preferable to do that than to embark on a lengthy appellate proceedings. For instance, if there is a short window of opportunity to investigate and collect evidence. That is the prosecutor's choice, and that choice must be respected. That is the regime of the Rome Statute. This also underscores why, in our view, this decision, the decision that is under challenge, was not a decision in relation to jurisdiction. But as we say, Your Honors, and it is true what Mr. Gaynor and others have said in the responses, that there are elements in the decision that are jurisdictional in nature. But in our view, the decision doesn't turn on those elements or those aspects. It's not that the situation that the pretrial chamber said, in relation to this cluster of crimes, I do not authorize the commencement of the investigation because they do fall outside the jurisdiction of the court, and in relation to those that I conclude fall within the jurisdiction of the court, interest of justice applies. No. They applied interest of justice across the board. So those jurisdictional elements were ultimately absorbed by the umbrella conclusion that the interest of justice applied to the situation as a whole. And it was on this basis that we decided that the proper way to bring this matter to Your Honor's attention was via Article 82.1d and not via Article 82.1a. Now, Your Honors, we have heard some invitations to engage in a purposive interpretation of the statute. We all like purposive interpretations. There is a limit to them. And I think in this sense, we would suggest that you approach with care some of the examples that have been given to you as instances in which the Appeals Chamber went beyond the terms of the statute. Actually, in our reading of the same examples, the Chamber always stayed within the express terms of the statute. For instance, the Chamber did not create an extra statutory right for victims to lead evidence. It merely said that under Article 68.3, victims can petition the trial chamber to exercise its authority under Article 69.3 to present evidence or to call for additional evidence. It always stayed within the boundaries of the strict letter of the statute. Finally, Your Honors, we have heard with interest the submissions made by Mr. Powell from the cross-border victims. One point that I have to make here is this appeal is not about case selection. It's not about the criteria the prosecution may use to determine when to investigate and what to investigate. This is not before you. This is not the matter in this appeal. And indeed, it is a prosecutor's prerogative to determine which incidents and which suspects it will bring to investigation. Having said this, we have recognized that if the pretrial chamber's findings are reversed in the manner we wish them to be reversed, the incidents included in the petition of the cross-border victims may properly be captured within the parameters of any future investigation. This concludes my submissions, Your Honor.
Thank you, Counsel, very much. And now I will turn to legal representative of Victims Group 1. You also may briefly respond if you wish.
Thank you, Mr. President.
Please.
I'm going to respond to submissions made by Mr. Jacobs and Mr. Sekulow and Mr. Guarilla only. I think in Mr. Jacobs' submissions, he suggested that we support an interpretation of the statute which would give affected communities the right to be recognised as victims and therefore the right to launch an appeal. That is not our position. We do not support that interpretation of Rule 85 of the Rules of Procedure and Evidence. Rule 85 clarifies that victims are natural persons who suffered from a crime within the court's jurisdiction, and Rule 85b goes on to include organisations or institutions that have sustained direct harm to any of their property which is dedicated to religion, education, art, science, or charitable purposes. And it goes on to define that exhaustively. Those institutions can participate if they can establish that they fall within that definition. We do not support an expansion of the term victim to cover affected communities. Secondly, my learned friend Mr. Sekulow referred to the existence of cogent legal arguments, that should be enough to prevent the court exercising jurisdiction. It's the job of counsel to present cogent legal arguments either for or against the exercise of jurisdiction, whether one is a prosecutor, whether one is a defense lawyer, whether one is a victim's lawyer. Cogent legal arguments themselves are never enough to prevent the exercise of jurisdiction. In respect of the standing of the United States to launch a challenge against an exercise of jurisdiction over United States nationals, I would point out that Article 19.2b does present a remedy for that. Article 19.2b is not limited to states parties. Any state may make a challenge under 19.2b. If it can, the United States would be more than welcome, I'm sure, to present evidence that it is genuinely investigating or prosecuting cases against United States nationals. That remedy exists for the United States, and they can start that, as far as I know, as soon as they like. And as part of that, they could present evidence and arguments concerning agreements between the government of Afghanistan and the government of the United States, and they can be ruled upon in the ordinary proceedings. That process is stated to apply to cases, but nevertheless it would not necessarily prevent the court from considering a challenge in relation to a situation. We agree with the Office of the Prosecutor and the OPCV that whatever you decide about the Article 82.1a versus Article 82.1d route to get here to this appeal, we do believe it's well within your jurisdiction to consider all issues which have been raised by the parties and to rule on all of them. Now, returning to the pre-trial chamber, which was an option suggested by Mr. Guarilla and others, is from the victim's perspective not an acceptable solution. It is not an acceptable solution for several reasons. There's nothing in the impugned decision to give us any reason to believe that the pre-trial chamber will take a different view on three questions. The first is the interests of justice question. The second is the territorial scope of the war crime of torture and any associated war crimes. And the third question is the territorial and temporal and substantive scope of any investigation which it might be minded to authorize. We believe they made very serious errors on all of those issues, and your honours must correct them, and returning to the pre-trial chamber is not an acceptable remedy from the victim's perspective. Now, finally, Mr. Guarilla, I think, when he was talking about the ways in which the court has purposively interpreted the statute, he said that they were all issues concerning matters which were quite clear under the statute already. Well, one thing that is quite clear under the statute already is the requirement in Article 63 that the accused shall be present at trial. Nothing could be clearer. On the clear understanding of those words, the accused shall be present at trial. Now, in the Ruto case, the accused was permitted to be absent from well over half of the trial days. I think it was considerably in excess of that percentage of 50%. And that has been upheld both by the trial chamber in the Ruta case and by the appeals chamber. That's an instance where the court took the view that a purposive interpretation of the statute actually meant reading Article 63 to mean that the accused may be absent from trial. Those are all of the arguments I have at this point. Thank you very much, Mr. President.
Thank you, Mr. Gaino. And then also the legal representatives of victims group 2 may also briefly respond. You choose the person who speaks.
Thank you, Your Honors. Particularly in light of the comments just made on behalf of LRV1, we'll give back our 5 minutes and stand ready to answer any questions from the bench. Thank you.
Thank you very much, Counsel. And the same questions to legal representative victims group 3. You may also briefly respond to the observations of the amici curia, please. Mr. Pietrzak.
Mr. President, Your Honors, I apologize. I did not hear the last several words you said.
Excuse me, I simply ask whether you would like to use your right to respond.
If it pleases the court, a short answer to 2 statements made today. One by Professor Paweł Wilinski acting as amicus curiae, and secondly to the statement made by the Office of the Prosecutor. Firstly, with regard to the opinion presented by Professor Paweł Wilinski, we agree absolutely that the standard established today will establish whether victims in the future, on a case-by-case basis, granted, will have the chance to appeal a refusal to authorize an investigation, and perhaps most importantly, in a situation when the Office of the Prosecutor refuses to do so. I think it needs to be stressed that the prosecutor has many factors she takes into account legitimately in deciding whether to appeal such a decision refusing to authorize an investigation, including public interest, policy issues. In the prosecutor's views, these factors may outbalance the criteria which are essential from the point of view of the victims, the justified interests of the victims and their rights to an effective remedy under the Rome Statute. With regard to the comments made by the Office of the Prosecutor just now, regarding the possibility of returning by the Office of the Prosecutor to the pretrial chamber with a renewed subsequent request for authorization of an investigation, perhaps with new evidence, new facts, new argumentation, as a sort of substitute for an appeal against the decision refusing to allow authorize an investigation. This, while it may be an interesting avenue for the Office of the Prosecutor to explore, is not an effective remedy available to victims. This is a course of action which is at the sole discretion of the prosecutor, who, as mentioned earlier, is not just the representative of the interests of the victims, but makes her decisions taking into account the other criteria and factors which I have just mentioned. If the Office of the Prosecutor seeks authorization a second time to investigate, the victim will be once again in a situation with no voice and no effective remedy if the pretrial chamber once again refuses to allow the investigation to go forward. So this scenario does not address the problem raised by the victims' legal representatives today, the lack of an effective remedy to a decision blocking the effective investigation which is necessary in order to vindicate procedurally the rights and the rights and freedoms of the victims represented before the court. Thank you.
Thank you, Counsel. And now we will have a question from the bench. I would like to invite Judge Howard Morrison to ask the first question for Mr. Gaynor. I understand.
Yeah.
Please.
Just one question for Mr. Gaynor. Under Article 63, what's your view of the proposition that an accused may be present through counsel?
Well, Your Honour, it's not an argument I had actually prepared myself for. The term "the accused" in the context of presence at trial, I would read to mean the physical presence of the accused person in the courtroom. At other parts of the proceedings, the interests of the accused are, of course, presented by his or her counsel. But in the reason why the presence at trial requirement was included in the Rome Statute was to do with having the accused present to hear the evidence against him as part of the process of justice, and not merely to put the accused on notice and to give the accused an opportunity to respond to the arguments made by the prosecutor. So the physical presence of the accused in the courtroom is an integral part of a fair trial from the perspective of victims. So I would read the presence of the accused in the courtroom to apply to the physical presence of the accused.
You said you hadn't anticipated or prepared the question. What else would you have said if you had? I think you. That's an observation, not a question.
Thank you, Counsel. There's also a question from my learned colleague, Judge Luz del Carmen Ibanez. Please. One question. Please, Judge Ibanez.
Thank you, Mr. Presiding Judge. The question is for the OTP about standing. By interpreting the wording either party of Article 82(1) as either of the prosecutor or the defense, excluding victims from those who can appeal a decision specifically at the Article 15 stage, would the defense be entitled to be the respondent of the appealing prosecutor? And if the response is yes, if the appeals chamber interprets it as such, limiting the wording either party to a prosecutor and defense, would it contradict its 24 October 2019 decision recognizing the OPCD as amicus curiae and not a party in these appeals? It's clear? Thank you very much.
Thank you, Your Honors. Yes, I think the question is clear. So I'll try to answer that within my limited abilities. The use of the term either party in the context of Article 82(1)(a is, as I think, I hope I made clear when I made my submissions, is because 82(1)(a deals with a wide range of decisions involving jurisdictional or admissibility issues. Now, some of the decisions will take place in the context of inter partes proceedings, in which case the defense and both the defense and the prosecutor may appeal. Some of those decisions may take place in the context of ex parte proceedings. For instance, going back to the Ntaganda appeal, the first appeal ever heard by this chamber, that was a matter of admissibility raised ex parte by the prosecutor in the context of an Article 58 proceeding related to the issuance of a warrant of arrest against Mr. Ntaganda. So there was no defense because it was an ex parte proceeding. Article 15, I think this same chamber has recognized that, is an ex parte proceeding par excellence. It is a proceeding triggered by the prosecution, and the only exception to that ex parte nature is the fact that The statute correctly allows victims to make representations in order for the pretrial chamber to have a more informed view of the request for authorization. But that doesn't turn the proceeding into an inter partes proceeding. It isn't. It remains an ex parte proceeding. So in that context, there is no either party. There is only one party, and that is there is the prosecutor, as it would happen in the context of any ex parte proceeding. And I do not see any contradiction. OPCD is not here as a party. It's here, if I understand its status correctly, as an amicus curiae, as someone making representations to assist the chamber in reaching the right result. So on the contrary, I think that there is a logic that connects all those elements.
So just to be clear, for you, for the OTP, in this concrete appeal, there is only one party, the OTP.
Yes, that is correct, Your Honor.
Okay.
There is one party, and there's a plurality of participants.
Okay.
Some of them are victim participants, some are Rule 103 amici. And all of them sharing the goal of assisting the chamber to reach the concrete result.
Okay. A second question, please, for the OTP. It's about jurisdiction.
Yes.
The scope of the impugned decision on jurisdiction. While the impugned decision noted in paragraph 25 that the prosecutor had indicated in her request that she had not reached a determination regarding the representation that individuals were attacked by airstrike drones. There has been any decision about that, but nevertheless, the impugned decision in its paragraph 40 limited the scope of this investigation or the investigation to this incident. Don't you think, does this limitation amount to a finding of the lack of jurisdiction over such alleged attacks or admissibility of a potential case emerging from those attacks? And also in the same vein, the impugned decision has made in its paragraph 54 regarding, and in others, regarding the crimes that allegedly commenced in Afghanistan.
Yes.
And were consummated outside Afghanistan. This is cross-borders victims, and then have made determinations regarding the crimes allegedly commenced in Afghanistan and consummated outside, and vice versa. Does the OTP think or not that those determinations amount to an admissibility or a jurisdiction question?
I think, Your Honor, there are two clusters of incidents, so to speak, that the chamber, in our view, in both cases, erroneously dealt with. The first cluster are incidents that the OTP did not include in its request for authorization. And pursuant to the long-established practice of this institution, we did so in the assumption that once authorization was granted, we could expand the investigation into other incidents that had not been included in the request, but fell within the temporal and territorial parameters of the situation, right? In relation to those, the chamber came back and said, well, no, actually, I'm only authorizing those incidents that you included in your request. And those that you did not include in your request are not authorized, and you have to come back with a new request for authorization. So it's a bit of an anomaly in the case law of this institution. But there is no jurisdictional element at all. It's only a procedural matter. We could conceivably come back and say, well, now we want you to authorize for investigation these other 50 incidents that were not included in the original authorization. Now, there is a second cluster of incidents, and there is a jurisdictional connotation of the chamber's findings. Those are those incidents that the chamber said because they start in one part of the territory or they continue in another, or because they are somehow connected to the conflict, but we don't think the nexus is sufficient, and they happen outside the territory of Afghanistan. They fall outside the scope of the court's jurisdiction. Now, as I tried imperfectly to explain in our reply, had the chamber then said in the dispositive part, in relation to these incidents, there is no jurisdiction, therefore there can be no authorization, and in relation to all the rest, interests of justice, we would have had a jurisdictional ruling coming from the pretrial chamber. And maybe that's what the pretrial chamber should have done, but it didn't. What it did was to say, in relation to all these incidents, regardless of whether they're committed or not, is an interest of justice determination. So in our view, the analysis of the pretrial chamber of those incidents, even if it has jurisdictional connotations, is simply a step in its defective reasoning leading to its blanket interest of justice determination, so to speak. It is a tricky situation in a way. I mean, we thought about this. We decided that the neat, clear, and procedurally appropriate avenue to bring this appeal before you was to bring the totality of the decision via Article 82(1)(d), because we concluded that there was no jurisdictional connotation. If there was one, it's confined to those cluster of incidents, which is a tiny component within a wider decision. So we think that you should look into that because it is a defective finding by the pretrial chamber, but you should look into that as part of the wider, equally defective, in our humble submission, decision on interest of justice. I hope that I have dealt with your question, Your Honor.
Just a follow-up question. Don't you think that this limitation put by the pretrial chamber is a limitation to the prosecutor's proprio motu power to exercise the court's or jurisdiction under Article 13C of the statute? Don't you think it's a limitation?
Which one? The determination?
The determination of the pretrial chamber on this last incident.
Well, it's difficult to tell, Your Honor. At the end of the day, ultimately, it should have been a jurisdictional finding, saying, you have requested authorization to deal with all these incidents, but I consider that actually these incidents I cannot authorize because they are manifestly outside of the scope of the court's territorial jurisdiction. So it would have been actually ultimately a decision under Article 15 simply saying authorization is not granted because jurisdiction is not present in relation to this. I don't think Article 13 applies here so much. I think it's an Article 15 determination. And within the universe of Article 15 determination, there is a jurisdictional element to that. The problem is, at the end of the day, the chamber did not rule on that basis. It ruled on the basis of interest of justice. So it's a bit of a confusing situation, probably for everybody, but this is the way we have analyzed it. I can hear you.
I've had a lot of work today. A final question, please, for the OTP. I'm sorry, I think that maybe this last question could be responded also for one of the representative of victims. I don't know who would like. It's about your submission this morning. According to one of your submissions this morning, regarding to the international human rights of victims to access to justice and to the right to an effective remedy. You said that the question of the recognition or enforcement of this rights, human rights, is for the states and not for the court. Maybe I'm wrong, but I think I heard that. Regarding that, I would like to ask you, if it's like that, then why or what is the purpose of Article 21(3) in the statute? And why, regarding also the wording, the concrete wording of the article that reads, Article 21(3), the application and interpretation of law pursuant to this article must be consistent with international recognized human rights. Regarding this wording, it is not may, it is not even shall, it is must. What are then the duties for judges regarding the wording of this article?
Contrary to Mr. Gaynor a moment ago, I thought this question could come, which doesn't mean that I'm prepared for it. But I will try to give you my best answer, Your Honor. I think that our position has been that, I was rushing at that point of my submissions this morning, so I may have not been clear, and then I apologize for that. It's not that the right as such has no application in the context of the court. It's that as all positive obligations under human rights law, they are conceived primarily as obligations for states vis-à-vis their own citizens. which requires this court to exercise a level of customization, so to speak, of those rights into the context of the Rome Statute in order to make those rights meaningful, but also at the same time compatible with the nature of the court and its unique functions. And perhaps, Your Honor, if I can draw a parallel example that Your Honor will be familiar with under the case law of the Inter-American Court of Human Rights, and chiefly the Barrios Altos case, which Your Honor is much more familiar than I am, there is an unfettered duty of all states, parties to the Inter-American Convention, to investigate and prosecute every single instance of human rights violations. It's an unfettered duty. There is no much discretion there. I mean, basically, states have to act and have to investigate and prosecute. And that has been a consistent jurisprudence of the Inter-American human rights system since Velázquez-Rodriguez up to Barrios Altos and beyond. Now, this court could not have an identical duty applied to it without derailing completely its ability to deliver justice. If we had to investigate and prosecute every single crime under situation countries, we would still be dealing with the first situation ever to be communicated to this court at the expense of other situations and other victims. So a right that makes perfect sense in the context of states and states' positive duties towards its own citizens, including the duty to deliver justice, has to be turned, has to be modified, has to be adjusted to the particular structure of the court. Otherwise, it doesn't make sense and it leads to absurd results. So in that sense, Your Honors, we are not saying that there is no such thing as a right to an effective remedy via Article 21.3. What we say is that that right has to be adjusted to the particular structure of the statute and to the existing provisions of the statute, including Article 68.3, including Article 19.3, including Article 15. And basically, in that context, that right we submit is respected. Victims have a right to petition to you. They're doing it. They have a right to petition to the pretrial chamber. They have done it. They have a right to petition to us. They do it on an ordinary basis. So that recourse is recognized by the Rome Statute system. I think that's our position.
Thank you. I don't know if there is someone from victims who would like to respond.
Yes, I'd be happy to, and I don't want to prevent anyone else from doing so, but I'd just like to point out a couple of things. It's clear from the statute itself, from the preamble, that it is the duty of every state to exercise its criminal jurisdiction over those responsible for international crimes. And it is the failure of states so often to exercise their jurisdiction over those responsible for international crimes. That is the reason why the International Criminal Court exists. That is the reason why we have an admissibility and jurisdictional process to filter out cases where the state is providing access to justice, where the state is providing a remedy to its citizens. It is only where the state is not providing those internationally recognized human rights that somebody can come before this court. So to answer your Honour's question, I believe that the 21.3 is very clear on its terms. Your Honours are obliged to interpret 82.1a in accordance with the internationally recognized human rights to a remedy and to justice. And the modification which must take place of that right once an applicant arrives at the International Criminal Court takes place, as Professor Slaughter and as Kate McIntosh have pointed out in their very well-researched submission. That takes place through the admissibility and jurisdictional filters. So we do argue that the idea that for victims coming before this court to be told, in essence, that your right to all of these human rights has got to be addressed to your home jurisdiction is absolutely misconceived. It completely misses the point of the Rome Statute. Thank you.
Thank you, Mr. Gainer. As I understand, also the legal representatives of Group 3 victims would like to take a position.
Mr. President, Your Honours, it was my intent to say a few words, but following Mr. Gainer's intervention, I cannot possibly say anything clearer or better than he already has. Thank you.
Thank you, Counsel. And Vito, please briefly respond?
Yes, and I don't profess to say much better than Mr. Gaynor already did. Just to add a gloss to what he said, I think to the extent that there's a question that international human rights are to be incorporated by the court itself, one need look back at the debate around the definition of gender and how the court would apply gender to see that it was the ICC that was to itself incorporate international human rights obligations. That's one brief point. And the second is not only does 21.3 include in our submissions the right to a remedy, truth, and non-repetition, it also includes the right to non-discrimination. And I think it's important to take that into account when looking at the factors, which we'll discuss tomorrow, that the pretrial chamber put forward, recognizing that there were crimes within this court, and then looking at the relative power dynamics between the parties, between the victims and the potential future defendants. Thank you.
Thank you, Counsel. And also a question from Judge Prost, please.
Thank you. I'm going to direct this to Ms. Hurst, albeit if other legal representatives of victims have a comment on it, because it relates to the argument that you made. I understand your argument with respect to the chapeau of 82.1 and your position that victims can be included in the term party in the chapeau. And accepting for the purposes of argument that position, what I'd like to know from you is what makes the victims in this particular instance a party?
I'm grateful for the question, Your Honour, because it does touch upon some of the points which I would have liked to elaborate further, but for the restrictions on time. And we're very much in agreement with the submissions which were made by Mr. Gaynor relating to the matters which the Chamber should look at in deciding whether in a specific instance where victims request to appeal, seek leave to appeal or attempt a direct appeal, whether that should be granted. And we agree with him that it's not a blanket invitation for victims to appeal in every single decision at this court, which the submissions of the prosecution at times has made it sound as though we're taking that position. In fact, we're saying that there are a limited range of factors which the judges in a particular case should look at in order to decide whether the victim's interests are so fundamentally affected. Now, in this case, the two key things which we've been focusing on are the nature of the Article 15 proceedings, and I don't need to repeat, I think, the submission which has been made by several participants in this hearing that the Article 15 proceedings are a gateway to all subsequent proceedings, every other opportunity for victims to access either a participatory opportunity or indeed reparations. But on top of that, there is an additional factor in this particular Article 15.4 decision, and that is that the pretrial chamber made its decision based largely, not exclusively, but largely on the interests of justice. And Article 53, paragraph 1c, expressly links to victims' interests. So in effect, what the pretrial chamber did was it closed the door for victims to have any access to justice, truth, or a remedy through this court, and it purported to do so, ironically, based on the very consideration in respect of which it was required to take into account victims' interests. And I think the very compelling observations which were made by the amicus on behalf of Afghani human rights organisations made the point very clearly that actually the pretrial chamber doesn't appear to have taken into account victims' interests at all in deciding on the interests of justice. So we say those are the two primary factors, but we do also agree with the other factors which were put forward by Mr. Gaynor, and we agree, for example, that it would be possible for the chamber to take into account other factors, for example, whether there is any prejudice which might result.
And just so that I'm clear, you're saying that those criteria bring the victims in this instance into the definition of party, because I interpreted Mr. Gaynor's submissions on this point, that those were criteria which compelled why they might be allowed to appeal, but I did not read them as particular factors that would make the victims a party under the chapeau of 82.1?
Your Honour, I think there are two possible pathways here in terms of statutory construction, and different decisions of the court in granting additional participatory rights, additional standing rights to victims before the court have taken different avenues. And on this, the prosecution is right that the chambers have not always said in terms the victims are parties. In some instances, what they've said is the term parties is not meant to exclude others who also have this right. And in this instance, the chamber could go either way. In our submission, we're talking about a purposive interpretation. The chamber can either say victims are parties, or Article 82.1 is not intended to be exclusively for use by parties. The purposive basis of either of those conclusions would be consistent, we say.
One more question, and it is directed to OPCV, please. I understand your argument was framed very much on the particular, as have been others, but yours most directly, on the right of standing existing here by virtue of the particular features of Article 15, and I just want to pursue that a little further with you so I fully understand. If this decision had been a decision of the prosecutor not to proceed on the basis of the interests of justice, and the pretrial chamber had declined to exercise its jurisdiction to review that decision, is it your position that the victims would have a right of appeal in those circumstances?
Your Honor, I think I would depend on the decision. When I was focusing on my submission this morning, I made it clear, I hope, two things. The first one is that by the virtue of the very nature of Article 15 proceedings, we could not but conclude that Article 15 proceedings for, in this specific case, can only deal with prosecution and victims, because the moment victims trigger an intervention in making submission to the court, they become to some extent party to that proceedings. This was the first argument. The second was that in this specific case, we need to take into account the context in which that decision was taken. So on one side, we interpret the fact that victims are authorized to make submissions as a sort of participatory, into brackets, if I can put that way, participatory rights, which trigger to some extent their possibility to become parties. On the other side, if this is considered by the chamber not, let's say, sufficient enough to interpret the term either party in Article 82.1a in this sense, we say there are at least other three grounds in this specific context which render victims party to that specific proceedings.
And just a brief follow-up on that, if this had been a decision of the pretrial chamber confirming a decision of the prosecutor not to proceed in the interests of justice, where there is no explicit submission of observations in the statutory provisions, again, do you say there would be a right of appeal in those circumstances?
I would say yes.
Thank you.
Thank you very much. As I understand, Judge Bossad has one additional question. Please.
Thank you, Mr. President. And good evening, everyone. My question goes to the representatives of the victims. And I'm confining my question to this particular case. Under Article 15.3, victims have a right to make representations. The chamber may allow them to do so. And I presume that even on appeal, it would be the same case. The prosecutor has appealed in this case. And
So my question is, why would you want the role of victims to be elevated to that of a party when you have a right to make representations in this particular case? Thank you.
Thank you.
Mr. Gaynor, please.
Thank you, Mr. President. Your Honour, thank you for your question. In this particular appeal, there is a great deal of overlap between the arguments presented by the prosecutor and by the various victims groups. However, there are certain areas where the emphasis has been somewhat different. There has been a difference of view as to the correct procedural route to get here. The prosecution presented 3 grounds to the pretrial chamber for certification. The pretrial chamber certified 2 of those 3 grounds. The 3rd ground, which was not certified, concerned the scope of any investigation that the pretrial chamber might be minded to authorize. To us, that is a critically important issue, and it would have been better had that been clearly on appeal. Now, at the same time, we are arguing that Your Honours should consider that ground on appeal. But in the instance of this particular appeal, there has been some divergence in the emphasis of the victims and the prosecutor. But I would invite Your Honours, and I know you'll do this anyway, to consider the broader view. There are going to be many situations where the interests of the victims and the interests of the prosecutor are going to diverge for very principled reasons. In the Kenya situation, the prosecutor has decided to suspend active investigation in Kenya against the express wishes of the victims of Kenya too, and that has been subject to litigation. In the Lubanga case, the prosecutor chose, again, for the best of reasons, to focus on the non-fatal offence of recruitment of child soldiers. In Mali, they chose initially to focus on the non-fatal offences concerning destruction of cultural property. In those situations, the victims might or they might not agree with the prosecutor's focus on non-fatal offences. They might believe that the investigation should cover fatal offences. I'm giving those as some examples of some areas, and I'm not suggesting bad faith on the part of the prosecutor in any way, but there are going to be differences in emphasis. And furthermore, as the prosecutor, as in my submissions, I talked about the prosecutor's address to the Assembly of States Parties, and she very properly raised the problem of resources. Is she going to have enough resources to properly investigate all situations? Will she in the future decide that Afghanistan should go the way of Kenya and it should not be actively investigated? That's the kind of decision where the interests of the victims and the interests of the prosecutor will diverge. So I would encourage Your Honours not only to consider this particular appeal, but to consider broader areas where the interests of the prosecutor and the victims will diverge. Thank you.
Thank you, Counsel. I have maybe the last question to Mr. Guarilla. It's related to your answer to one of the questions of Judge Ibanez. And the question is, do you think that it's correct for the pretrial chamber to limit the scope of the investigation to the certain incidents in the authorization decision? I ask this question because this decision is to be issued before the investigation starts. It's, of course, it could have some implication. And the question related, linked to the first one, is what would be the value of the PTC's determinations related to the incidents covered or not covered by the jurisdiction of the court, in particular when the PTC refuses to authorize the investigation?
Thank you, Your Honor, for this very important question. As you know, we completely disagree with that approach by the pretrial chamber, and is indeed part of our appeal. What we think is basically this was one of the building blocks of the decision, in the sense that it led to a narrow, a tunnel view of the pretrial chamber as to how the situation was composed, which in turn informed its erroneous interest of justice decision. We also know that it is an anomaly, as I said earlier, within the consistent case law of this court that has always, precisely for the reason that Your Honor suggested, we haven't even started an investigation. There is a preliminary examination. Some incidents, illustrative incidents, are proposed to the pretrial chamber for the purposes of guiding the chamber in its assessment, but it is necessarily a non-exhaustive list of incidents that has been initially presented for the purposes of the Article 15 scrutiny. And all pretrial chambers to date have interpreted the system working in that way. Even recently, the Myanmar-Bangladesh decision goes back to the good jurisprudence, so to speak, and basically makes clear that it takes the sample incidents as such, presented by the prosecutor, and authorizes a broad investigation where basically other incidents may be incorporated. It is an anomaly, and it's an anomaly that basically conspires against basic principles of efficiency of investigation, of judicial economy, and creates problems for everybody, including victims, in the sense that basically every time that the prosecutor wants to add a single incident to its investigation plan, it has to go and get supplementary authorization of the pretrial chamber. And ultimately, Your Honors, it intrudes into the independence of the prosecutor to effectively select what to investigate, how to investigate it, and how to move forward. So in this sense, we urge Your Honors actually to reverse that component of the decision.
No. Thank you very much. The schedule for the hearing is now complete. The hearing will resume tomorrow at 9:30. I would to thank everyone, especially all the court officers, interpreters, reporters, as well as the technicians and security, for assisting with today's proceedings. I thank all of you. The hearing is now adjourned.
All rise.